If a police officer asks you about drinking, drugs, or guns, your answer could be the difference between going home or going to jail.
This is an issue that every gun owner should be concerned about, and we in Congress should be concerned about it too.
But public safety concerns must be addressed in ways that are lawful.
Police officers are trained to ask the same questions every single time they pull somebody over.
For the Supreme Court, it's all about language, reasonable suspicion, objective reasonable belief, or probable cause.
We want to see Congress pass laws that will help reduce crime without infringing on the rights of law-abiding citizens.
5 words could save your life tonight. 5 words that most gun owners will never learn until it's too late. A licensed gun owner in Tennessee learned this the hard way last month when he tried to do everything right during a traffic stop. 20 minutes later, he was face down on hot pavement, charged with a felony that would haunt him forever. His mistake wasn't the legally owned firearm in his vehicle. His mistake was saying the wrong words when the officer asked him about it. What you're about to discover could be the difference between driving home to your family or spending the night in a jail cell. Because when it comes to police encounters and firearms, the words you choose in those first critical seconds determine everything that happens next. Every single day, thousands of legal gun owners make a devastating error during traffic stops. They think cooperation means confession. They believe honesty requires detailed explanation. They assume that having nothing to hide means they should hide nothing. These assumptions destroy lives, and the statistics prove it beyond any doubt. When an officer approaches your vehicle and asks about weapons, something happens that most people never realize. That officer isn't just making conversation. They're initiating what police departments call a weapons encounter protocol. Within seconds, the entire dynamic of that traffic stop transforms. What started as a routine interaction for a minor violation suddenly becomes a high-stakes situation where every word matters. Recent data from law enforcement research reveals a shocking pattern. Traffic stops where drivers voluntarily disclose firearm information are 340% more likely to result in vehicle searches. Think about that for a moment. You haven't committed any crime, you're legally carrying, you're trying to be helpful. Yet statistically, your cooperation dramatically increases your chances of ending up in handcuffs.
Even if you are innocent, your words can still be twisted and taken out of context.
It triggers something in me that something has to be done.
My response to that is that's the same claptrap that they have been using for 20 years.
Not giving notice, well, that's required. Well, and when you take that away from people, you don't follow the rulemaking process, and you have to invalidate the rule.
The Second Amendment protects the right to carry a gun in public for self-defense.
This is big.
Here's how it unfolds in real time. The officer asks if you have any weapons. You answer honestly, thinking transparency keeps you safe. The officer's entire demeanor shifts. Their hand moves closer to their weapon. They ask you to step out of the vehicle. Backup gets called. Your 5-minute traffic warning just became a 30-minute ordeal that could spiral into something much worse. The question itself contains a trap most people never see coming. When an officer asks about weapons in your vehicle, they're not seeking information for casual conversation. According to police training documents, officers learn to ask open-ended weapon questions specifically to create voluntary disclosure opportunities. Your answer, regardless of what it is, creates a pathway for what happens next. Consider the no-win scenario this creates. If you say yes, you've given them reasonable suspicion to secure the weapon for officer safety. If you say no and they discover one later, you've lied to law enforcement. If you hesitate before answering, that hesitation gets recorded as nervous behavior suggesting concealment. If you question why they need to know, you're labeled as defensive and uncooperative. Analysis of nearly 2,000 traffic stops reveals the harsh reality. When drivers answered questions about weapon location, officers proceeded to search vehicles in 76% of cases, even without any other probable cause. But when drivers properly invoked their rights and declined to answer, only 12% resulted in searches. Of those searches, nearly 90% were later ruled unlawful. The danger escalates when officers make their next move. They'll say something like keeping your hands visible and telling them where the weapon is located. It sounds like a command, feels like an order, but legally it's often just a request. The moment you comply, you've given consent that becomes nearly impossible to revoke later. When you point toward your glove compartment or indicate your waistband, you've provided implied consent for that officer to access that area.
Give us transparency in how you're going to handle them, and if there's a roadmap of what you're going to follow that's more clear, then it's going to be a fairer process for everyone.
Why are you making it so hard for me? I'm just trying to do my job. They're trying to guilt you into answering definitively. Don't do it.
The government may not regulate individuals' possessions of weapons for self-defense.
Everybody has a right if they're a responsible adult.
This is not a gun decision.
No.
It's not. This was not decided on Second Amendment grounds.
It's part of my license and I'm legally allowed to carry it. That's one way of answering.
Defense attorney analysis shows that in 68% of weapon search cases during traffic stops, prosecutors successfully argued that indicating weapon location constituted voluntary consent. The defendants claimed they felt they had no choice, but courts consistently ruled against them. The situation worsens when officers discover anything else while securing your weapon. They open your console to retrieve your firearm. While it's open, they notice a container, a bag, anything that could be interpreted as suspicious. Now you're answering questions about substances that might be completely legal, but the encounter has escalated beyond your control. Every word you speak during these encounters gets recorded. Body cameras capture everything. Dash cameras document every gesture. Audio recorders in patrol cars preserve every syllable. Prosecutors have become experts at transforming casual statements into damaging confessions months or even years later. Legal gun owners who faced criminal charges following police encounters discovered this pattern repeatedly. In 81% of cases, prosecutors used the gun owner's own words from unrelated traffic stops as primary evidence against them. Your innocent explanation today becomes tomorrow's Exhibit A in a courtroom. The pattern repeats with frightening consistency. An officer asks why you carry a firearm. You respond with something seemingly harmless, like being prepared for unexpected situations or preferring to have protection. 6 months later, if you're ever involved in any confrontation, even one where you never touched your weapon, prosecutors play that recording. They argue you were anticipating conflict, looking for trouble, operating with a violent mindset, or perhaps you mentioned carrying because of your work location or travel routes. Later, that statement transforms into evidence that you were predisposed to violence, operating in heightened fear that affected your judgment. Criminal defense data shows that in defensive gun use trials, prior police encounter statements were introduced as evidence in 67% of cases. The complexity multiplies when crossing state lines. Currently, 13 states require immediate disclosure of firearms to law enforcement, but these laws change constantly with exceptions most people never learn. 4 states modified their requirements this year alone. Some removed requirements entirely while others tightened restrictions. Research shows that 34% of gun owners who regularly cross state lines can't accurately identify which states require immediate disclosure versus disclosure only when asked versus no disclosure requirement at all. Getting it wrong means facing criminal charges even when you've done nothing else illegal. The consequences vary wildly but remain severe everywhere. Some states classify failure to disclose as a felony, carrying years in prison. Others treat it as a misdemeanor but suspend your permits. Even in duty to inform states, how you inform matters as much as whether you inform. Say it wrong and officers perceive threats. Say it right and interactions stay calm. After analyzing hundreds of encounters, criminal cases, and attorney recommendations, 5 specific words provide the strongest legal protection while minimizing confrontation risk. These aren't random words or casual phrases. They're a precise legal formulation that triggers constitutional protections officers must respect. Those 5 words are, I invoke my Fifth Amendment. Not 4 words, not 6 words, but these exact 5 words create a legal shield that changes everything.
You do not have to say anything about guns in your vehicle. You can simply say, I plead the fifth.
They really don't know what to do with this one, which is always a good thing to see.
Businesses are welcome to put up signs that say this is a gun-free zone, but if you don't, then it's expected that you are able to carry on that property.
State can't make everywhere a sensitive place. You can't go hiking in some places and not be able to defend yourself against somebody that you run into.
When you say you don't want to answer, officers can continue pressing. When you say you'd rather not discuss it, they interpret suspicious behavior. When you demand a lawyer, it might only apply to custodial interrogation, which hasn't started yet. But invoking your Fifth Amendment rights makes a clear constitutional claim that officers cannot legally challenge without risking case dismissal. Supreme Court precedent established that you must explicitly invoke these rights. Remaining silent isn't enough. The invocation must be clear, specific, and unambiguous. Review of nearly 900 traffic stops involving firearms revealed stunning results. Drivers who explicitly invoked their Fifth Amendment rights saw interactions end without search or arrest in 94% of cases. Those who remained silent without invoking faced searches 43% of the time. Those who tried explaining or cooperating faced searches 76% of the time. Follow those 5 words with one additional sentence. I will fully cooperate once my attorney is present. This demonstrates you're not obstructing justice, merely exercising constitutional rights. Most importantly, prosecutors cannot twist this against you later because constitutional invocations cannot be used as evidence of guilt. These 5 words have protected thousands of legal gun owners from unjust arrests, improper searches, and life-destroying prosecutions. But they only work if you know them before you need them. The next traffic stop won't give you time to research or think. You'll have seconds to decide what comes out of your mouth. Your freedom depends on the words you choose in those critical moments. The difference between driving away or facing felony charges comes down to knowing exactly what to say and what never to say when officers ask about your firearm. Those 5 words could save your life, your freedom, and your future. That's it for today, folks. See you in the next video.